Thank you, everyone. Please be seated. We are here today for the submission of 3 cases. The first case will be State of Iowa versus Wilson. That will be submitted without oral argument. Before we get to the case that's going to have oral argument, I want to welcome Audubon, Go Wheelers. I don't know if you're going to like me when I tell you where I'm from, but I'm from Harlan. I know, I saw some faces. But anyway, I just want to go real quick through our bench. One thing we all have in common with you is we all went to a high school somewhere. We appreciate very much your teacher or your school administrators that allowed for you to have this opportunity to watch an oral argument at appellate court. And I just want to let you know that the real trial for this case happened probably in, I'm not sure what county it was. I don't have it off the top of my head. Lynn County, which is Cedar Rapids. That trial was a while ago, so you won't see witnesses or anything. You'll see the court ask questions of the lawyers. So just to give you an idea, I'm Susie Christensen. I used to be a juvenile court judge and Audubon was one of my counties. So I bet I know your folks and some people that your parents work with. And I'm from Harlan High School. Go Cyclones. And we'll go in order of seniority.
Bettendorf High School. Go Bulldogs.
Ed Mansfield, Lexington High School in Lexington, Massachusetts. That's where the Revolutionary War started, where the local militia first confronted the British. So we were called the Minutemen.
Good afternoon. I'm Christopher McDonald. I graduated from Des Moines Lincoln High School, class of '92, home of the Fighting Lincoln Rail Splitters.
I'm Dana Oxley. I grew up in Greenfield and went to Greenfield High School, Greenfield Tigers. It's now Nottoway Valley, I believe the Wolverines.
Hi, I'm Matt McDermott. I went to Kemper and Carroll, home of the Mighty Knights.
I'm David May. I went to high school in Kirksville, Missouri, and we were the Tigers.
All right, now we're going to begin with the case of State versus Lee. And the state will begin with Ms. Knipfer, and you will also tell them where you went to high school, as well as you. Ms. Dixit, thank you.
I'm Shellie Knipfer, and I went to high school at English Valleys, home of the Bears. In State versus Copenhagen, it is clear that the unit of prosecution for a robbery is the intent to commit a theft, such that wherever there is only one intent to commit a theft, there can only be one robbery, regardless of how many assaults. The defendant also today would like the court to go back and revisit Copenhagen to address footnote 2, which asserts that we no longer recognize the single larceny rule. As I said, in Copenhagen, the unit of prosecution is the intent to commit a theft. If you look at the statute and how it is structured, it starts off with when a person having the intent to commit a theft does one of the following to further that intent or to escape therefrom, and then it lists 3 different types of assaults.
Could you briefly, for the benefit of our audience, say what the facts were in this case?
Okay. The facts of this case were that defendant Lee entered the home of Sandy and Joe, and they were an elderly couple, and he demanded money. He demanded money from a safe, and to both of them, and then he assaulted them in attempting to get to that safe. And he ended up dragging Joe downstairs to the safe and where it was open, and he took 2 bags of money and left. And so the question is, was there 1 robbery or was there 2 robberies? And again, we assert that there is just 1.
I wrote a dissent in Copenhagen that it sounds like you agree with. But we don't need to go there, right? In order for your client to prevail, don't we just have to say that? So why don't we, focusing on that, articulate for me why there was only, and for everyone else, why was there only 1 intended theft here?
Theft because the defendant entered that home with one one criminal intent, and that was to take the money from the safe. He knew Joe had been keeping money, everybody knew, in the safe, like he would get cash for different jobs and would put it down in that safe. So the defendant apparently knew about this, and that's what he wanted. And so, as I said, you have like one purpose in mind here, in that he wants to take that money.
So if we were to find that there is sufficient evidence only to support one robbery conviction, what relief are you requesting, and what authority for that relief?
I'm asking the court to to combine the two offenses into one. It's really kind of muddy, and some courts refer to it as a reversal. Some say they're combining. The end result is the person walks off with only one conviction.
You said it's a little bit muddy, so can you answer a procedural question for me? The defendant did not object to the marshalling instructions, is that right?
No, but he did raise the issue of intent in a motion for, not arrested judgment, but anyway, judgment of acquittal.
As this jury was instructed, there were two marshalling instructions at number 20 and 23, and then there were different elements in each instruction, one related to an assault on Joe, and then one related to an assault on Sandra. Is that right? So I guess, aren't we going to judge the sufficiency of the evidence by looking at the evidence compared to these marshalling instructions? And if that's right, how is this issue even before us? Is this a sentencing issue? Can you clarify?
I think of this more kind of like the one homicide rule. You have to do a sufficiency analysis to determine whether there's, one dead body, two dead bodies, and then, if you have one dead body, you have the one homicide rule. You can't charge them with multiple homicides, or you can charge them, but you can't convict them of multiple homicide offenses.
To a merger, which you can raise after the fact, right? Because in
the cases, Wissing and another case I can't think of, but anyway, the court, I think, raised it on its own.
And it's kind of, the defendant really doesn't have standing to object to two separate charges, in the sense that it might be possible that the jury would, I guess it could have been instructed at if you find assaulting either or, but it's possible the jury could have found that the defendant, that Lee assaulted the husband and not the spouse, or the wife and not the spouse, and therefore and therefore you needed to have both of them in the instructions. It seems like the evidence was pretty strong. He assaulted both of them, but nonetheless, that does seem possible.
Jury had to make their finding, and there's no differentiation. There's no way that the jury would know about the intent aspect of it. I'm not sure. He did have an intent to commit a theft. It's just he only had one, and so it's one robbery. I don't know how you put that in the jury instructions.
That was in that safe, it belonged to both of them, right? Is it?
She took money from this pool also.
So if he assaults each of the victims and takes money from each of the victims, isn't that two robberies?
No, not under Copenhagen, because again, you have one intent. You enter that home with one intent, to steal the money in the safe. And
The defendant entered a bank with the intent to steal from the bank, and then he addressed separately two different tellers, and we said that was two robberies. This seems to me, I don't know why that would be different. You have two people with commonly owned money, and he separately beats both of them. So that is Copenhagen.
analysis in Copenhagen is that he's taken the money from the tellers. And not only is it just that he's taken the money from the tellers, not the bank, there is actually a break in time that he steals from one teller, then there's a brief break in time, and then he goes and turns and steals from the second teller.
The couple here, he beat one for a while, then he'd move on to the next one and beat that one for a while.
The taking was of the one.
He was trying to find the money. He was demanding the money. He threw the wife up against the wall to the point where the outside video showed us shaking. He dragged the husband down the stairs. So each of them was an effort to get to the money, wasn't it?
Yes, it was, but he still entered the home, and his actions were to take one thing, and that was the money in the basement.
Cleaner cut than Copenhagen? I think in Copenhagen you could say that when Copenhagen walked into that bank, he intended to steal money only from that bank and not from individual tellers. Here, your client went into their home and was stealing money from both of them. It was their money, wasn't it?
It's like one piece of property that has joint interest. And so it's still just one intended theft. But I'd like to,
State then is correct, and that if we're going to reconsider Copenhagen, the relevant unit of prosecution should not be the intent to commit theft, it's the assaults.
you do that. I mean, well, you can't do that because the way the statute is written. And so the statute is written with the unit of prosecution being the intended theft. In those cases that, if you look at them, then analysis, the statutes will start with the taking from the person or in the presence of the person. I mean, that's one type of statute's written. And
Statute says the unit of prosecution is theft. It seems like
when Haver analyzed it, was that that was that was the unit of theft.
I think, unless I'm wrong, and Ms. Dixit will correct me, they're saying if we're going to do anything with Copenhagen, we should reinterpret the statute correctly, and that the unit of prosecution is 1711(1) sub A, B, and C, and that those are actually the units of prosecution.
Well, I think that treating it as an assault statute as opposed to a robbery/theft statute is kind of a misconstruing of the purpose of the robbery statutes. Because you think about when you have a robbery, the person's acting with the purpose of obtaining something of value. That's really the
Full language of the statute, it says, a person having the intent to commit a theft, the person does any of the following acts to assist or further the commission of the intended theft or the person's escape from the scene with or without the stolen property. So it does, I mean, we were unanimous. I mean, we could have been wrong, but we were unanimous on that point in Copenhagen, I think 7-0 or however many of us sat on the case, that's focusing on an intent to commit a theft. And then it says any of the following acts, and there's a series of acts you can commit, 1, 2, 3, any selection of those, but if you still only have the intent to commit a theft, then you haven't committed more than one robbery.
and I'd like to read just well, again, I went back for purpose, but I cited a case in my additional authorities, Collins. It's a West Virginia case, and there's a note in there, and in the case cites no authority, but I thought it was interesting, where it says, cases that a victim or / assault oriented, those oriented type cases, failed to recognize that at common law, robbery was considered an aggravated larceny, and by allowing multiple robbery convictions when only one larceny was committed, these courts have altered the substantive definition of robbery as developed in common law. As I said, West Virginia didn't cite any authority for that, they just said it, but I think it was an interesting way to look at it.
Provisions matter in your analysis. So under the old code, you actually had to commit a larceny to be found guilty of robbery. And that's no longer true. And now it's just having the intent to commit a theft. We don't have larceny anymore. It seems like the code revisions moved away from a theft property model of robbery to a violence assault model of robbery. And if that's right, and other states have done the same thing, when you're looking at robbery as a crime of violence rather than a property crime, doesn't it make sense that the unit of prosecution would be each individual violent act rather than the intent to commit a theft?
I still think it's still a crime with the main purpose being the commission of the theft, but we punish it more harshly because of these aggravating factors of the different types of assault.
Theft, correct? So it's not a property crime, it's a violent crime.
Crime to the extent that person had that intent to commit a theft. So they're still trying to take something of value.
Doesn't it matter that theft is not a lesser included offense of robbery?
That theft isn't? No, it's not. Yes, but I still think that the crime of robbery primarily is, or the crime of robbery is an intent to commit a theft crime. And so it starts there.
To Justice McDermott's point, if you're categorizing the offense and the defendant doesn't have to actually complete a theft to be guilty of robbery, and theft is not a lesser included offense of robbery, but these assaults and other things are, doesn't that indicate that it's a crime of violence and that's what's being punished? So in this case, if Mr. Lee had not actually obtained any of the property and he just came in and beat these two people and then fled, that would still be a robbery, right?
Oh, I say that again, or can you repeat?
Money from the safe and he came in and beat these two elderly people, it's still a robbery, even though he committed no property crime.
The intent to commit a theft, yes. I see my time is up, and so for the reasons stated here and in the briefs, we respectfully request this court to combine defendants' convictions for robbery in the first degree.
Good afternoon. My name is Anna Dixit, and I went to Murrieta Valley High School in Southern California. Go Nighthawks. May it please the court, your honors, it is immaterial to the question of guilt or innocence of robbery that property was or was not actually stolen. As your honors have been discussing with Ms. Knipfer, the actual theft, whether it is completed or not, is not a requirement to get a conviction under robbery. In Copenhagen, this court was tasked with placing robbery on a spectrum. And on one end of that spectrum, we've got theft, and on the other end of the spectrum, we've got assault. And Copenhagen chose to place it a lot closer to theft, but you reached the right conclusion. You found that Copenhagen had committed 2 robberies.
Yeah, but that was different. That was where there was a bunch of money that was obtained from one teller, then a break, then a bunch of money from another teller. Only one intended theft here, correct or not?
In Copenhagen, there were found that there were 2 separate intentions to commit a theft.
Right?
I would disagree with that. If we're applying Copenhagen, if without any changes that I am suggesting, if we apply Copenhagen.
Separate intended thefts.
When Lee walked into that home, he beat up Sandy and he asked her for the safe and for the money in the safe. Then he turns to Joe and asks him for the money in the safe. He takes 2 bags of money out of that safe. Sandy testified that the money belonged to Joe from his gambling winnings, from selling equipment, but it also belonged to her. Your Honor, I would disagree because I believe that when Lee walked into that home, he intended to thieve Sandy and he intended to steal from Joe. He intended to steal property that was both separately and jointly owned.
But, I mean, that would be an astounding proposition that anytime you commit any kind of a theft or robbery from, one spouse, that then that's automatically two thefts or two robberies just because it's, they jointly own their property.
What if he stole their car?
Again, under my theory of the case, that would be two. I mean, their ownership of the items is not even in the robbery statute. If I am in someone's home and someone walks in and steals my friend's laptop and beats me while they do it, that's still a robbery, even though I don't even own that laptop.
Two robberies.
It was two robberies in this case.
In your scenario where someone comes in and takes your friend's laptop and beats you, if your friend is there too, I assume.
There, that's two robberies. If she isn't there and I am alone in her house, that's one robbery because it's one assault. So
Does that sit with Copenhagen? And the distinction that it was needed in that case by the majority to say it was only two because there was one teller got money, a second teller got money.
I'm drawing the distinction here. With the laptop example, if we apply Copenhagen as it currently stands, you are correct, Your Honor. That is one robbery because there is only one item taken, one intention for a theft. But under the proposal that I have to change how we applied Copenhagen, to change the analysis of how we look at robbery, that would be two thefts. And
For example, for you, okay, somebody walks into the bank, there's 100 people standing around in the lobby of the bank, points the gun all around, takes one bag of money and leaves. Is that 100 robberies?
it's 100 robberies.
Oh, isn't it?
Do is we task prosecutors with the charging decisions. So whether it's reasonable to charge 100 robberies if he's waving the gun around at 100 people, we have to ask ourselves, can he or she prove that those 100 people felt threatened or were assaulted by the behavior of the defendant?
It says someone who having an intent to commit a theft in the course of, that in the course thereof, I'm paraphrasing, commits any of the following acts. Then as we read it in Copenhagen, kind of the driver is this intended theft plus any of the following acts. So you could have multiple acts, you still only have one intended theft, one robbery. That's how we read the statute.
With the intention to commit a theft. And if an individual walks into a bank and waves a gun around at 10 people, he may have the intention to commit a theft, but he has put 10 separate people in fear of serious injury.
Address that by, I think in this case, we have 2 counts of robbery, 1, and then the husband had willful injury causing serious injury, and the wife was willful injury causing bodily injury. We're addressing those individual harms in a different criminal statute. Do we need to also double up and have robberies on top of all of those?
That, Your Honor. First would be that in this case, because he physically beat them and caused serious injury and bodily injury, the prosecutor in their discretion was able to charge willful injury. But take, for example, Copenhagen. Copenhagen was convicted of 1 theft and 2 robberies. The underlying fact that he went and threatened and scared the tellers of the bank was not separately punished.
Assaults, though, right?
In that,
That are much more minor. In this case, the willful injury was pretty darn serious.
to my second point, even the willful injury, even the intimidation, setting that aside, those are lower charges. There is a reason that robbery is classified as a Class B felony in its first degree. There is a reason for that, and it is because in the commission of a theft, we take the use of violence very seriously.
Another question. What role does stare decisis play? Copenhagen's been around 10 years. The Court of Appeals at least has applied it. I assume trial judges have applied it, that saying the unit of prosecution is not the number of people assaulted, but the number of intended thefts.
Your Honor, first and most importantly would be This is a unique case because we are here today not under regular circumstances where one side is saying, you did it right, please apply as is, and the other side is saying you should change it. A unique situation in that both sides are asking you to look at this again.
For it,
Not only,
without throwing Copenhagen out.
especially in this case, with the particular facts of this case, if Copenhagen is applied as is, because he went up to both of these individuals and demanded money from the safe separately, you can find 2 thefts and you can find 2 robberies. But if we're going back to the principle of stare decisis, not only are the 2 sides asking you to find in opposite directions, they're telling you that as you've currently analyzed the statute, we would still win. So now you've got 4 different avenues by which it can be decided, and there is a grievous error here that needs to be corrected if 4 different alternatives could be possible.
Grievous error is,
The grievous error would be that Copenhagen put the focus of the robbery statute on theft when it should have been on assault. As Justice McDermott said, the lesser included of robbery is not theft. It is assault. This is a victim-based crime. This is an assault-based crime.
Now, would you say then, I used to do a little work about fires back in practice. We had a term called arson for profit. And it seems like you're kind of saying that what a robbery is sort of violence for profit. Is that a fair way to do it?
Say that it is violence for the attempt of profit, but I think it's important to remember we don't need to complete a theft. If Lee had walked in and beat up these 2 poor individuals and taken nothing, that would still have been a robbery.
to actually get some money downstairs or something.
Intention of profit.
Here too.
It would have been 2 robberies because
You still haven't parsed the statute for me. I mean, it says again, with the intent to commit a theft is any of the following acts. So clearly under the concept of the statute, you can have multiple acts within the scope of a single robbery. So, but you, as long as you have an intended theft, that's what we said in Copenhagen. That seems like the logical reading of the statute.
well, even with that reading of the statute, approaching Sandy and demanding her money and then beating her up, and then approaching Joe and demanding his money and beating him up, that shows 2 intents to commit a theft. But even under 1 intent to commit a theft, he goes in intending to commit a theft, and he does 2 separate actions, 3 or 4 separate actions, because he beat them on multiple occasions. But what we're saying is, if we apply it as Copenhagen reads, we're essentially saying that the aggravation of combining a theft with a assault, you're allowed to assault as many people as you want.
The argument, and I've showed you, I've given you example where that argument I think makes no sense at all. Like the 100 people in the bank, you can go to prison for 2,500 years. That doesn't make any sense. So we can make policy arguments, but don't we have to go back to the wording of the statute? I mean, the legislature could have worded it differently, like some other states do, in a way which would make it that the unit of prosecution is the number of assaults. And besides, you could still charge the defendant for any injuries or that they commit. That's a separate crime that is not a lesser included of robbery.
And, to go back to the stare decisis question, we're looking at legislative acquiescence, and we're trying to see, if they had a problem with Copenhagen, they had 10 years to fix it. Why haven't they changed the language of that statute? Well, to that, I have two answers. One and most important answer here is that you reach the right conclusion. In Copenhagen, you got 2 robberies. So if the legislature is looking at it and saying, okay, whatever analysis they put, or if our intention was to punish an individual that does such an action for 2 robberies, they got there in the end. So getting involved in that, they may have seen that as unnecessary.
Yeah, former prosecutor, and I'm wondering, are we going to make it harder for there to be robbery charges if, let's say that there's a situation, this case, the Lee case, except you don't have any evidence of where's the money. Maybe that's in his mind. He's coming there to get the $50,000 in the safe, but there's no way to prove it, and he never finds it, and just plain beats him up terribly, and then leaves. Is the state going to charge and or prove robbery if that really was his intent?
we end up in the same situation whether Copenhagen is applied as it currently stands or not. Because if he comes in there and there is no evidence that he has any intention to commit a theft, we don't even get one robbery. So if that is the worry that are we going to make this harder, we're actually going to make it easier on prosecutors to be able to charge, because we make a clear bright line rule that says how many assaults were there. Can you prove an intention to commit a theft? Great, that's how many robberies you charge. We don't have to. And, you know, in Copenhagen, in cases that came before it, we talk about the rule of lenity. And in statutory interpretation, you know, that's a consideration when there's any kind of ambiguity. And I would say that my interpretation of the robbery statute actually favors the rule of lenity, because instead of charging an individual with 3 thefts and 3 robberies and 3 willful injuries, all we're charging them with is the 1 theft. And then everything else falls under the umbrella of however many assaults have been committed. And as the justices have already pointed out, I think the first question we have to ask ourselves is, was this properly preserved? It has been raised as a sufficiency challenge, but this is actually a question about the marshalling instructions themselves. And the law of the case is that they only needed an intent to commit a theft. Lee only needed 1 intent to commit a theft, and the assaults on either Sandy or Joe, and there was sufficient evidence to support that. So based on that,
So a legal sentence? I mean, isn't there a path?
it would be an illegal sentence if the conviction for robbery could not be sustained with substantial evidence. But if the law of the case says this is how you prove robbery twice, and the jury found sufficient evidence and substantial evidence in the record supports the marshalling instructions as they were presented, then there is no illegal sentence, because if you get convicted of 2 robberies, you're allowed to sentence for 2 robberies.
The jury was not asked to make a finding that there were 2 separate intended thefts. The jury, I mean, so if the law is that you can only be convicted of 1 robbery for 1 intended theft, then our standard approach, and you can raise it after trial, is to in effect merge. I mean, we don't use the technical term merger because one is not a lesser included offense. It's 2 copies of the same offense, but that's what we do, I mean, right? And we don't require error preservation at trial.
A properly raised substantial evidence, a properly raised illegal sentence here. There is substantial evidence in this record to support the finding of 2 thefts, and it's for those reasons that I ask you to relook at Copenhagen, but ultimately affirm the 2 robberies. Thank you, Your Honors.
Okay, I have some scattered thoughts here. First of all, as to the jury instruction question, no, it's correct that you go to sentencing, and then that's when the court decides, no, this is an illegal sentence, they must be combined. That's what you do in such as the 1 homicide cases where the defendant, you know, effectively was guilty of the various homicides, but when it went before the court said, nope, you can only have 1 homicide and combine them, or into only a conviction for 1 homicide. It should be noted here, too, that in this particular case, the defendant was only charged with 1 theft, so clearly the state didn't think that there were 2 thefts going on. And another point is that robbery is a crime, it's its own crime, just like burglary, sexual assault. So unit of prosecution in a sexual assault crime would be the sex act. But we also, a lesser included of a sexual assault is assault. So that doesn't make it an assault crime per se.
A crime of violence. I mean, which is the point here? I mean, the lesser includeds are violent crimes, as in sexual assault is a violent crime. The property is, you don't have to prove it at all, right? I mean, I think we've established that. If Mr. Lee took no money from these victims, he still commits a robbery, even if just because he intended to.
Was to take property. So it's still a theft-oriented crime.
Really isn't relevant what's a lesser included and what's not a lesser included. You just look at the wording of the statute and you figure out what's the unit of prosecution.
Went through Copenhagen. Who owned the money in Copenhagen?
I think is where, I think Copenhagen personally is a close call. Because if you go to other jurisdictions where a bank robbery took place, they've found that you had one victim, the bank. But in this case, in Copenhagen, this court analyzed or defined the victim. So that's, I mean, really, how do you define the victim? And in Copenhagen, the court defined the victim as the clerks because they were the ones experiencing the assault at. But the money in this case was owned by Joe and Sandy.
Possession of the money in this case.
Sandy.
Okay, so he comes in, he beats them, he beats her, says, give me your money. She has possession of money, that's hers. It's constructively possessed or in her safe. He owns money. Lee comes in and beats him and says, give me your money. He's also in possession of money, which I think you just said. Why isn't that two thefts?
Criminal intent.
But then Copenhagen, the bank owned the money in Copenhagen. These two tellers happened to be standing at a window where the bank's money was in a drawer. And he said, give me the bank's money. And we said, that's two robberies. I don't see how that's different.
That they formed the intent to commit a theft with the first teller, a break in time, and then formed another intent to commit a theft with the second teller. There's two intents.
The intent was to take from who?
Intent is to take the money from the safe.
I kind of get the feeling that you think that's Joe, because it was his money. He's the one that got it. My question is that based on the evidence and the testimony, it actually kind of almost became more Sandy's. She was the person in charge of this money. She was the one possessing it recently. She couldn't even handle the combination anymore and left it open, and that's how he got in so easy.
I mean, but it's still one object, the money, and he intended to take that. That was one intent to commit a theft.
Joe's money was in the basement, and her money was in the upstairs dresser, and he took it from both places. What would that be like?
Well, there are different thoughts on that, and in some situations, they found like it's the place being the home, then maybe it was just one criminal act of going in and taking all the money from the house, or another thought is that he went to the basement to steal that money, and then he went upstairs to steal other money, and they break it down into two intents. So it depends how the court breaks down the analysis and defines its terms.
You can summarize.
Reasons stated here, defendant asked this court to find that there was only one criminal intent. We asked the court to continue its analysis that it set forth in Copenhagen and reverse defendant's conviction on one one robbery.
State versus Lee is hereby submitted. We'll have a brief pause, and it's my understanding the Audubon students need to leave. You got to go back to school, more homework. And we'll let you guys leave the room and let the lawyers do a switch here for our next case.